Cartagena Protocol on Biosafety to the Convention on Biological Diversity, done at Montreal on the 29th of January 2000. Entry into force, the 11th of September 2003. The parties to this protocol. Being parties to the Convention on Biological Diversity, hereinafter referred to as the Convention. Recalling Article 19, paragraphs 3 and 4, and Articles 8, G, and 17 of the Convention. Recalling also Decision 2/5 of the 17th of November 1995 of the Conference of the Parties to the Convention to develop a protocol on biosafety, specifically focusing on transboundary movement of any living modified organism resulting from modern biotechnology that may have adverse effect on the conservation and sustainable use of biological diversity, setting out for consideration, in particular, appropriate procedures for advance-informed agreement. Reaffirming the precautionary approach contained in Principle 15 of the Rio Declaration on Environment and Development. Aware of the rapid expansion of modern biotechnology and the growing public concern over its potential adverse effects on biological diversity, taking also into account risks to human health. Recognizing that modern biotechnology has great potential for human well-being if developed and used with adequate safety measures for the environment and human health. Recognizing also the crucial importance to humankind of centers of origin and centers of genetic diversity. Taking into account the limited capabilities of many countries, particularly developing countries, to cope with the nature and scale of known and potential risks associated with living modified organisms. Recognizing that trade and environment agreements should be mutually supportive with a view to achieving sustainable development. Emphasizing that this protocol shall not be interpreted as implying a change in the rights and obligations of a party under any existing international agreements. Understanding that the above recital is not intended to subordinate this protocol to other international agreements. Have agreed as follows. Article 1. Objective. In accordance with the precautionary approach contained in Principle 15 of the Rio Declaration on Environment and Development, the objective of this protocol is to contribute to ensuring an adequate level of protection in the field of the safe transfer, handling and use of living modified organisms resulting from modern biotechnology that may have adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health, and specifically focusing on transboundary movements. Article 2. General Provisions. 1. Each party shall take necessary and appropriate legal, administrative and other measures to implement its obligations under this protocol. 2. The parties shall ensure that the development, handling, transport, use, transfer and release of any living modified organisms are undertaken in a manner that prevents or reduces the risks to biological diversity, taking also into account risks to human health. 3. Nothing in this protocol shall affect in any way the sovereignty of states over their territorial sea established in accordance with international law, and the sovereign rights and the jurisdiction which states have and their exclusive economic zones and their continental shelves in accordance with international law, and the exercise by ships and aircraft of all states of navigational rights and freedoms as provided for in international law and as reflected in relevant international instruments. 4. Nothing in this protocol shall be interpreted as restricting the right of a party to take action that is more protective of the conservation and sustainable use of biological diversity than that called for in this protocol, provided that such action is consistent with the objective and the provisions of this protocol and is in accordance with that party's other obligations under international law. 5. The parties are encouraged to take into account, as appropriate, available expertise, instruments and work undertaken in international forums with competence in the area of risks to human health. Article 3. Use of terms. For the purposes of this protocol. A. Conference of the parties means the conference of the parties to the convention. B. Contained use means any operation, undertaken within a facility, installation or other physical structure, which involves living modified organisms that are controlled by specific measures that effectively limit their contact with, and their impact on, the external environment. C. Export means intentional transboundary movement from one party to another party. D. Exporter means any legal or natural person, under the jurisdiction of the party of export, who arranges for a living modified organism to be exported. E. Import means intentional transboundary movement into one party from another party. F. Importer means any legal or natural person, under the jurisdiction of the party of import, who arranges for a living modified organism to be imported. G. Living modified organism means any living organism that possesses a novel combination of genetic material obtained through the use of modern biotechnology. H. Living organism means any biological entity capable of transferring or replicating genetic material, including sterile organisms, viruses and viroids. I. Modern biotechnology means the application of a. In vitro nucleic acid techniques, including recombinant deoxyribonucleic acid, DNA, and direct injection of nucleic acid into cells or organelles, or b. Fusion of cells beyond the taxonomic family that overcome natural physiological reproductive or recombination barriers and that are not techniques used in traditional breeding and selection. J. Regional economic integration organization means an organization constituted by sovereign states of a given region, to which its member states have transferred competence in respect of matters governed by this protocol and which has been duly authorized, in accordance with its internal procedures, to sign, ratify, accept, approve or accede to it. K. Transboundary movement means the movement of a living modified organism from one party to another party, save that for the purposes of Articles 17 and 24 transboundary movement extends to movement between parties and non-parties. Article 4. Scope. This protocol shall apply to the transboundary movement, transit, handling and use of all living modified organisms that may have adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health. Article 5. Pharmaceuticals. Notwithstanding Article 4 and without prejudice to any right of a party to subject all living modified organisms to risk assessment prior to the making of decisions on import, this protocol shall not apply to the transboundary movement of living modified organisms which are pharmaceuticals for humans that are addressed by other relevant international agreements or organizations. Article 6. Transit and contained use. 1. Notwithstanding Article 4 and without prejudice to any right of a party of transit to regulate the transport of living modified organisms through its territory and make available to the biosafety clearinghouse, any decision of that party, subject to Article 2, Paragraph 3, regarding the transit through its territory of a specific living modified organism. The provisions of this protocol with respect to the advance informed agreement procedure shall not apply to living modified organisms in transit. 2. Notwithstanding Article 4 and without prejudice to any right of a party to subject all living modified organisms to risk assessment prior to decisions on import and to set standards for contained use within its jurisdiction. The provisions of this protocol with respect to the advance informed agreement procedure shall not apply to the transboundary movement of living modified organisms destined for contained use undertaken in accordance with the standards of the party of import. Article 7. Application of the advance informed agreement procedure. 1. Subject to Articles 5 and 6. The advance informed agreement procedure in Articles 8 to 10 and 12 shall apply prior to the first intentional transboundary movement of living modified organisms for intentional introduction into the environment of the party of import. 2. Intentional introduction into the environment in paragraph 1 above does not refer to living modified organisms intended for direct use as food or feed, or for processing. 3. Article 11 shall apply prior to the first transboundary movement of living modified organisms intended for direct use as food or feed, or for processing. 4. The advance informed agreement procedure shall not apply to the intentional transboundary movement of living modified organisms identified in a decision of the Conference of the Parties serving as the meeting of the parties to this protocol as being not likely to have adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health. Article 8. Notification. 1. The party of export shall notify, or require the exporter to ensure notification to, in writing, the competent national authority of the party of import prior to the intentional transboundary movement of a living modified organism that falls within the scope of Article 7, Paragraph 1. The notification shall contain, at a minimum, the information specified in Annex I. 2. The party of export shall ensure that there is a legal requirement for the accuracy of information provided by the exporter. Article 9. Acknowledgement of receipt of notification. 1. The party of import shall acknowledge receipt of the notification, in writing, to the notifier within 90 days of its receipt. 2. The acknowledgement shall state, a. the date of receipt of the notification, b. whether the notification, prima facie, contains the information referred to in Article 8, c. whether to proceed according to the domestic regulatory framework of the party of import or according to the procedures specified in Article 10. 3. The domestic regulatory framework referred to in paragraph 2, c. above, shall be consistent with this protocol. 4. A failure by the party of import to acknowledge receipt of a notification shall not imply its consent to an intentional transboundary movement. Article 10. Decision procedure. 1. Decisions taken by the party of import shall be in accordance with Article 15. 2. The party of import shall, within the period of time referred to in Article 9, inform the notifier, in writing, whether the intentional transboundary movement may proceed. A. Only after the party of import has given its written consent or b. After no less than 90 days without a subsequent written consent. 3. Within 270 days of the date of receipt of notification, the party of import shall communicate, in writing, to the notifier and to the biosafety clearinghouse the decision referred to in paragraph 2, a. above. A. Approving the import, with or without conditions, including how the decision will apply to subsequent imports of the same living modified organism. B. Prohibiting the import. C. Requesting additional relevant information in accordance with its domestic regulatory framework or Annex I in calculating the time within which the party of import is to respond. The number of days it has to wait for additional relevant information shall not be taken into account or d. Informing the notifier that the period specified in this paragraph is extended by a defined period of time. 4. Except in a case in which consent is unconditional, a decision under paragraph 3 above shall set out the reasons on which it is based. 5. A failure by the party of import to communicate its decision within 270 days of the date of receipt of the notification shall not imply its consent to an intentional transboundary movement. 6. Lack of scientific certainty due to insufficient relevant scientific information and knowledge regarding the extent of the potential adverse effects of a living modified organism on the conservation and sustainable use of biological diversity in the party of import, taking also into account risks to human health, shall not prevent that party from taking a decision, as appropriate, with regard to the import of the living modified organism in question as referred to in paragraph 3 above, in order to avoid or minimize such potential adverse effects. 7. The conference of the parties serving as the meeting of the parties shall, at its first meeting, decide upon appropriate procedures and the mechanisms to facilitate decision-making by parties of import. Article 11. Procedure for living modified organisms intended for direct use as food or feed, or for processing. 1. A party that makes a final decision regarding domestic use, including placing on the market, of a living modified organism that may be subject to transboundary movement for direct use as food or feed, or for processing shall, within 15 days of making that decision, inform the parties through the biosafety clearinghouse. This information shall contain, at a minimum, the information specified in Annex 2. The party shall provide a copy of the information, in writing, to the national focal point of each party that informs the Secretariat in advance that it does not have access to the biosafety clearinghouse. This provision shall not apply to decisions regarding field trials. 2. The party making a decision under paragraph 1 above, shall ensure that there is a legal requirement for the accuracy of information provided by the applicant. 3. Any party may request additional information from the authority identified in paragraph B of Annex 2. 4. A party may take a decision on the import of living modified organisms intended for direct use as food or feed, or for processing, under its domestic regulatory framework that is consistent with the objective of this protocol. 5. Each party shall make available to the biosafety clearinghouse copies of any national laws, regulations and guidelines applicable to the import of living modified organisms intended for direct use as food or feed, or for processing, if available. 6. A developing country party or a party with an economy in transition may, in the absence of the domestic regulatory framework referred to in paragraph 4 above, and in exercise of its domestic jurisdiction, declare through the biosafety clearinghouse that its decision prior to the first import of a living modified organism intended for direct use as food or feed, or for processing, on which information has been provided under paragraph 1 above, will be taken according to the following. A. A risk assessment undertaken in accordance with Annex 3 and b. A decision made within a predictable time frame, not exceeding 270 days. 7. Failure by a party to communicate its decision according to paragraph 6 above, shall not imply its consent or refusal to the import of a living modified organism intended for direct use as food or feed, or for processing, unless otherwise specified by the party. 8. Lack of scientific certainty due to insufficient relevant scientific information and knowledge regarding the extent of the potential adverse effects of a living modified organism on the conservation and sustainable use of biological diversity in the party of import, taking also into account risks to human health, shall not prevent that party from taking a decision, as appropriate, with regard to the import of that living modified organism intended for direct use as food or feed, or for processing, in order to avoid or minimize such potential adverse effects. 9. A party may indicate its needs for financial and technical assistance and capacity building with respect to living modified organisms intended for direct use as food or feed, or for processing. Parties shall cooperate to meet these needs in accordance with Articles 22 and 28. Article 12. Review of decisions. 1. A party of import may, at any time, in light of new scientific information on potential adverse effects on the conservation and sustainable use of biological diversity, taking also into account the risks to human health, review and change a decision regarding an intentional transboundary movement. In such case, the party shall, within 30 days, inform any notifier that has previously notified movements of the living modified organism referred to in such decision, as well as the biosafety clearinghouse, and shall set out the reasons for its decision. 2. A party of export or a notifier may request the party of import to review a decision it has made in respect of it under Article 10 where the party of export or the notifier considers that a change in circumstances has occurred that may influence the outcome of the risk assessment upon which the decision was based, or b. additional relevant scientific or technical information has become available. 3. The party of import shall respond in writing to such a request within 90 days and set out the reasons for its decision. 4. The party of import may, at its discretion, require a risk assessment for subsequent imports. Article 13. Simplified procedure. 1. A party of import may, provided that adequate measures are applied to ensure the safe intentional transboundary movement of living modified organisms in accordance with the objective of this protocol, specify in advance to the biosafety clearinghouse a. cases in which intentional transboundary movement to it may take place at the same time as the movement is notified to the party of import, and b. imports of living modified organisms to it to be exempted from the advance informed agreement procedure. Notifications under subparagraph a, above, may apply to subsequent similar movements to the same party. 2. The information relating to an intentional transboundary movement that is to be provided in the notifications referred to in paragraph 1, a, above, shall be the information specified in Annex 1. Article 14. Bilateral, regional and multilateral agreements and arrangements. 1. Parties may enter into bilateral, regional and multilateral agreements and arrangements regarding intentional transboundary movements of living modified organisms, consistent with the objective of this protocol and provided that such agreements and arrangements do not result in a lower level of protection than that provided for by the protocol. 2. The parties shall inform each other, through the biosafety clearinghouse, of any such bilateral, regional and multilateral agreements and arrangements that they have entered into before or after the date of entry into force of this protocol. 3. The provisions of this protocol shall not affect intentional transboundary movements that take place pursuant to such agreements and arrangements as between the parties to those agreements or arrangements. 4. Any party may determine that its domestic regulations shall apply with respect to specific imports to it and shall notify the biosafety clearinghouse of its decision. Article 15. Risk assessment. 1. Risk assessments undertaken pursuant to this protocol shall be carried out in a scientifically sound manner, in accordance with Annex 3 and taking into account recognized risk assessment techniques. Such risk assessments shall be based, at a minimum, on information provided in accordance with Article 8 and other available scientific evidence in order to identify and evaluate the possible adverse effects of living modified organisms on the conservation and sustainable use of biological diversity, taking also into account risks to human health. 2. The party of import shall ensure that risk assessments are carried out for decisions taken under Article 10. It may require the exporter to carry out the risk assessment. 3. The cost of risk assessment shall be borne by the notifier if the party of import so requires. Article 16. Risk management. 1. The parties shall, taking into account Article 8, g, of the Convention, establish and maintain appropriate mechanisms, measures and strategies to regulate, manage and control risks identified in the risk assessment provisions of this protocol associated with the use, handling and transboundary movement of living modified organisms. 2. Measures based on risk assessment shall be imposed to the extent necessary to prevent adverse effects of the living modified organism on the conservation and sustainable use of biological diversity, taking also into account risks to human health, within the territory of the party of import. 3. Each party shall take appropriate measures to prevent unintentional transboundary movements of living modified organisms, including such measures as requiring a risk assessment to be carried out prior to the first release of a living modified organism. 4. Without prejudice to paragraph 2 above, each party shall endeavor to ensure that any living modified organism, whether imported or locally developed, has undergone an appropriate period of observation that is commensurate with its life cycle or generation time before it is put to its intended use. 5. Parties shall cooperate with a view to a. Identifying living modified organisms or specific traits of living modified organisms that may have adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health, and b. Taking appropriate measures regarding the treatment of such living modified organisms or specific traits. Article 17. Unintentional transboundary movements and emergency measures. 1. Each party shall take appropriate measures to notify affected or potentially affected states, the Biosafety Clearinghouse and, where appropriate, relevant international organizations, when it knows of an occurrence under its jurisdiction resulting in a release that leads, or may lead, to an unintentional transboundary movement of a living modified organism that is likely to have significant adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health in such states. The notification shall be provided as soon as the party knows of the above situation. 2. Each party shall, no later than the date of entry into force of this protocol for it, make available to the Biosafety Clearinghouse the relevant details setting out its point of contact for the purposes of receiving notifications under this article. 3. Any notification arising from paragraph 1 above, should include a. Available relevant information on the estimated quantities and relevant characteristics and/or traits of the living modified organism. b. Information on the circumstances and estimated date of the release, and on the use of the living modified organism in the originating party. c. Any available information about the possible adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health, as well as available information about possible risk management measures. d. Any other relevant information, and e. A point of contact for further information. 4. In order to minimize any significant adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health, cash party, under whose jurisdiction the release of the living modified organism referred to in paragraph 1 above, occurs, shall immediately consult the affected or potentially affected states to enable them to determine appropriate responses and initiate necessary action, including emergency measures. Article 18. Handling, transport, packaging and identification. 1. In order to avoid adverse effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health, each party shall take necessary measures to require that living modified organisms that are subject to intentional transboundary movement within the scope of this protocol are handled, packaged and transported under conditions of safety, taking into consideration relevant international rules and standards. 2. Each party shall take measures to require that documentation accompanying a. living modified organisms that are intended for direct use as food or feed, or for processing, clearly identifies that they may contain living modified organisms and are not intended for intentional introduction into the environment, as well as a contact point for further information. The conference of the parties serving as the meeting of the parties to this protocol shall take a decision on the detailed requirements for this purpose, including specification of their identity and any unique identification, no later than 2 years after the date of entry into force of this protocol. b. living modified organisms that are destined for contained use clearly identifies them as living modified organisms and specifies any requirements for the safe handling, storage, transport and use, the contact point for further information, including the name and address of the individual and institution to whom the living modified organisms are consigned, and c. living modified organisms that are intended for intentional introduction into the environment of the party of import, and any other living modified organisms within the scope of the protocol, clearly identifies them as living modified organisms, specifies the identity and relevant traits and/or characteristics. Any requirements for the safe handling, storage, transport and use, the contact point for further information, and, as appropriate, the name and address of the importer and exporter, and contains a declaration that the movement is in conformity with the requirements of this protocol applicable to the exporter. 3. The Conference of the Parties serving as the meeting of the parties to this protocol shall consider the need for and modalities of developing standards with regard to identification, handling, packaging and transport practices, in consultation with other relevant international bodies. Article 19. Competent national authorities and national focal points. 1. Each party shall designate one national focal point to be responsible on its behalf for liaison with the Secretariat. Each party shall also designate one or more competent national authorities, which shall be responsible for performing the administrative functions required by this protocol and which shall be authorized to act on its behalf with respect to those functions. A party may designate a single entity to fulfill the functions of both focal point and competent national authority. 2. Each party shall, no later than the date of entry into force of this protocol for it, notify the Secretariat of the names and addresses of its focal point and its competent national authority or authorities. Where a party designates more than one competent national authority, it shall convey to the Secretariat, with its notification thereof, relevant information on the respective responsibilities of those authorities. Where applicable, such information shall, at a minimum, specify which competent authority is responsible for which type of living modified organism. Each party shall forthwith notify the Secretariat of any changes in the designation of its national focal point or in the name and address or responsibilities of its competent national authority or authorities. 3. The Secretariat shall forthwith inform the parties of the notifications it receives under paragraph 2 above, and shall also make such information available through the Biosafety Clearinghouse. Article 20. Information sharing and the Biosafety Clearinghouse. 1. A Biosafety Clearinghouse is hereby established as part of the clearinghouse mechanism under Article 18, paragraph 3, of the Convention, in order to a. Facilitate the exchange of scientific, technical, environmental and legal information on, and experience with, living modified organisms, and b. Assist parties to implement the protocol, taking into account the special needs of developing country parties, in particular the least developed and small island developing states among them, and countries with economies in transition, as well as countries that are centers of origin and centers of genetic diversity. 2. The Biosafety Clearinghouse shall serve as a means through which information is made available for the purposes of paragraph 1 above. It shall provide access to information made available by the parties relevant to the implementation of the protocol. It shall also provide access, where possible, to other international biosafety information exchange mechanisms. 3. Without prejudice to the protection of confidential information, each party shall make available to the Biosafety Clearinghouse any information required to be made available to the Biosafety Clearinghouse under this protocol, and a. Any existing laws, regulations and guidelines for implementation of the protocol, as well as information required by the parties for the advance informed agreement procedure. b. Any bilateral, regional and multilateral agreements and arrangements. C. Summaries of its risk assessments or environmental reviews of living modified organisms generated by its regulatory process, and carried out in accordance with Article 15, including, where appropriate, relevant information regarding products thereof, namely, process materials that are of living modified organism origin. Containing detectable novel combinations of replicable genetic material obtained through the use of modern biotechnology. D. Its final decisions regarding the importation or release of living modified organisms, and E. Reports submitted by it pursuant to Article 33, including those on implementation of the Advance Informed Agreement procedure. 4. The modalities of the operation of the Biosafety Clearinghouse, including reports on its activities, shall be considered and decided upon by the Conference of the Parties serving as the meeting of the parties to this protocol at its first meeting, and kept under review thereafter. Article 21. Confidential information. 1. The party of import shall permit the notifier to identify information submitted under the procedures of this protocol or acquired by the party of import as part of the Advance Informed Agreement procedure of the protocol that is to be treated as confidential. Justification shall be given in such cases upon request. 2. The party of import shall consult the notifier if it decides that information identified by the notifier as confidential does not qualify for such treatment, and shall, prior to any disclosure, inform the notifier of its decision, providing reasons on request, as well as an opportunity for consultation and for an internal review of the decision prior to disclosure. 3. Each party shall protect confidential information received under this protocol, including any confidential information received in the context of the Advance Informed Agreement procedure of the protocol. Each party shall ensure that it has procedures to protect such information and shall protect the confidentiality of such information in a manner no less favorable than its treatment of confidential information in connection with domestically produced living modified organisms. 4. The party of import shall not use such information for a commercial purpose, except with the written consent of a notifier. 5. If a notifier withdraws or has withdrawn a notification, the party of import shall respect the confidentiality of commercial and industrial information, including research and development information as well as information on which the party and the notifier disagree as to its confidentiality. 6. Without prejudice to paragraph 5 above, the following information shall not be considered confidential. A. The name and address of the notifier. B. A general description of the living modified organism or organisms. C. A summary of the risk assessment of the effects on the conservation and sustainable use of biological diversity, taking also into account risks to human health, and D. Any methods and plans for emergency response. Article 22. Capacity building. 1. The parties shall cooperate in the development and/or strengthening of human resources and institutional capacities in biosafety, including biotechnology to the extent that it is required for biosafety, for the purpose of the effective implementation of this protocol, in developing country parties, in particular the least developed and small island developing states among them, and in parties with economies in transition, including through existing global, regional, sub-regional and national institutions and organizations and, as appropriate, through facilitating private sector involvement. 2. For the purposes of implementing paragraph 1 above, in relation to cooperation, the needs of developing country parties, in particular the least developed and small island developing states among them, for financial resources and access to and transfer of technology and know-how in accordance with the relevant provisions of the Convention, shall be taken fully into account for capacity building in biosafety. Cooperation in capacity building shall, subject to the different situation, capabilities and requirements of each party, include scientific and technical training in the proper and safe management of biotechnology, and in the use of risk assessment and risk management for biosafety, and the enhancement of technological and institutional capacities in biosafety. The needs of parties with economies in transition shall also be taken fully into account for such capacity building in biosafety. Article 23. Public awareness and participation. 1. The parties shall, a. promote and facilitate public awareness, education and participation concerning the safe transfer, handling and use of living modified organisms in relation to the conservation and sustainable use of biological diversity, taking also into account risks to human health. In doing so, the parties shall cooperate, as appropriate, with other states and international bodies. b. Endeavor to ensure that public awareness and education encompass access to information on living modified organisms identified in accordance with this protocol that may be imported. 2. The parties shall, in accordance with their respective laws and regulations, consult the public in the decision-making process regarding living modified organisms and shall make the results of such decisions available to the public, while respecting confidential information in accordance with Article 21. 3. Each party shall endeavor to inform its public about the means of public access to the biosafety clearinghouse. Article 24. Non-parties. 1. Transboundary movements of living modified organisms between parties and non-parties shall be consistent with the objective of this protocol. The parties may enter into bilateral, regional and multilateral agreements and arrangements with non-parties regarding such transboundary movements. 2. The parties shall encourage non-parties to adhere to this protocol and to contribute appropriate information to the biosafety clearinghouse on living modified organisms released in, or moved into or out of, areas within their national jurisdictions. Article 25. Illegal transboundary movements. 1. Each party shall adopt appropriate domestic measures aimed at preventing and, if appropriate, penalizing transboundary movements of living modified organisms carried out in contravention of its domestic measures to implement this protocol. Such movements shall be deemed illegal transboundary movements. 2. In the case of an illegal transboundary movement, the affected party may request the party of origin to dispose, at its own expense, of the living modified organism in question by repatriation or destruction, as appropriate. 3. Each party shall make available to the biosafety clearinghouse information concerning cases of illegal transboundary movements pertaining to it. Article 26. Socio-economic considerations. 1. The parties, in reaching a decision on input under this protocol or under its domestic measures implementing the protocol, may take into account, consistent with their international obligations, socio-economic considerations arising from the impact of living modified organisms on the conservation and sustainable use of biological diversity, especially with regard to the value of biological diversity to indigenous and local communities. 2. The parties are encouraged to cooperate on research and information exchange on any socio-economic impacts of living modified organisms, especially on indigenous and local communities. Article 27. Liability and redress. The conference of the parties serving as the meeting of the parties to this protocol shall, at its first meeting, adopt a process with respect to the appropriate elaboration of international rules and procedures in the field of liability and redress for damage resulting from transboundary movements of living modified organisms, analyzing and taking due account of the ongoing processes in international law on these matters, and shall endeavor to complete this process within 4 years. Article 28. Financial mechanism and resources. 1. In considering financial resources for the implementation of this protocol, the parties shall take into account the provisions of Article 20 of the Convention. 2. The financial mechanism established in Article 21 of the Convention shall, through the institutional structure entrusted with its operation, be the financial mechanism for this protocol. 3. Regarding the capacity building referred to in Article 22 of this protocol, the Conference of the Parties serving as the meeting of the parties to this protocol, in providing guidance with respect to the financial mechanism referred to in paragraph 2 above, for consideration by the Conference of the Parties, shall take into account the need for financial resources by developing country parties, in particular the least developed and the small island developing states among them. 4. In the context of paragraph 1 above, the parties shall also take into account the needs of the developing country parties, in particular the least developed and the small island developing states among them, and of the parties with economies in transition, in their efforts to identify and implement their capacity-building requirements for the purposes of the implementation of this protocol. 5. The guidance to the financial mechanism of the Convention in relevant decisions of the Conference of the Parties, including those agreed before the adoption of this protocol, shall apply, mutatis mutandis, to the provisions of this article. 6. The developed country parties may also provide, and the developing country parties and the parties with economies in transition avail themselves of, financial and technological resources for the implementation of the provisions of this protocol through bilateral, regional and multilateral channels. Article 29. Conference of the Parties serving as the meeting of the parties to this protocol. 1. The Conference of the Parties shall serve as the meeting of the parties to this protocol. 2. Parties to the Convention that are not parties to this protocol may participate as observers in the proceedings of any meeting of the Conference of the Parties serving as the meeting of the parties to this protocol. When the Conference of the Parties serves as the meeting of the parties to this protocol, decisions under this protocol shall be taken only by those that are parties to it. 3. When the Conference of the Parties serves as the meeting of the parties to this protocol, any member of the Bureau of the Conference of the Parties representing a party to the Convention but, at that time, not a party to this protocol, shall be substituted by a member to be elected by and from among the parties to this protocol. 4. The Conference of the Parties serving as the meeting of the parties to this protocol shall keep under regular review the implementation of this protocol and shall make, within its mandate, the decisions necessary to promote its effective implementation. It shall perform the functions assigned to it by this protocol and shall a. Make recommendations on any matters necessary for the implementation of this protocol. b. Establish such subsidiary bodies as are deemed necessary for the implementation of this protocol. c. Seek and utilize, where appropriate, the services and cooperation of, and information provided by, competent international organizations and intergovernmental and non-governmental bodies. d. Establish the form and the intervals for transmitting the information to be submitted in accordance with Article 33 of this protocol and consider such information as well as reports submitted by any subsidiary body. e. Consider and adopt, as required, amendments to this protocol and its annexes, as well as any additional annexes to this protocol, that are deemed necessary for the implementation of this protocol and f. Exercise such other functions as may be required for the implementation of this protocol. 5. The rules of procedure of the Conference of the Parties and financial rules of the Convention shall be applied, mutatis mutandis, under this protocol, except as may be otherwise decided by consensus by the Conference of the Parties serving as the meeting of the parties to this protocol. 6. The first meeting of the Conference of the Parties serving as the meeting of the parties to this protocol shall be convened by the Secretariat in conjunction with the first meeting of the Conference of the Parties that is scheduled after the date of the entry into force of this protocol. Subsequent ordinary meetings of the Conference of the Parties serving as the meeting of the parties to this protocol shall be held in conjunction with ordinary meetings of the Conference of the Parties, unless otherwise decided by the Conference of the Parties serving as the meeting of the parties to this protocol. 7. Extraordinary meetings of the Conference of the Parties serving as the meeting of the parties to this protocol shall be held at such other times as may be deemed necessary by the Conference of the Parties serving as the meeting of the parties to this protocol, or at the written request of any party, provided that, within 6 months of the request being communicated to the parties by the Secretariat, it is supported by at least 1/3 of the parties. 8. The United Nations, its specialized agencies and the International Atomic Energy Agency, as well as any state member thereof or observers thereto not party to the convention, may be represented as observers at meetings of the Conference of the Parties serving as the meeting of the parties to this protocol. Any body or agency, whether national or international, governmental or non-governmental, that is qualified in matters covered by this protocol and that has informed the Secretariat of its wish to be represented at a meeting of the Conference of the Parties serving as a meeting of the parties to this protocol as an observer, may be so admitted, unless at least 1/3 of the parties present object. Except as otherwise provided in this article, the admission and participation of observers shall be subject to the rules of procedure, as referred to in paragraph 5 above. Article 30. Subsidiary bodies. 1. Any subsidiary body established by or under the Convention may, upon a decision by the Conference of the Parties serving as the meeting of the parties to this protocol, serve the protocol, in which case the meeting of the parties shall specify which functions the body shall exercise. 2. Parties to the Convention that are not parties to this protocol may participate as observers in the proceedings of any meeting of any such subsidiary bodies. When a subsidiary body of the Convention serves as a subsidiary body to this protocol, decisions under the protocol shall be taken only by the parties to the protocol. 3. When a subsidiary body of the Convention exercises its functions with regard to matters concerning this protocol, any member of the Bureau of that subsidiary body representing a party to the Convention but, at that time, not a party to the protocol, shall be substituted by a member to be elected by and from among the parties to the protocol. Article 31. Secretariat. 1. The Secretariat established by Article 24 of the Convention shall serve as the Secretariat to this protocol. 2. Article 24, Paragraph 1, of the Convention on the Functions of the Secretariat shall apply, mutatis mutandis, to this protocol. 3. To the extent that they are distinct, the costs of the Secretariat services for this protocol shall be met by the parties hereto. The Conference of the Parties serving as the meeting of the parties to this protocol shall, at its first meeting, decide on the necessary budgetary arrangements to this end. Article 32. Relationship with the Convention. Except as otherwise provided in this protocol, the provisions of the Convention relating to its protocols shall apply to this protocol. Article 33. Monitoring and reporting. Each party shall monitor the implementation of its obligations under this protocol, and shall, at intervals to be determined by the Conference of the Parties serving as the meeting of the parties to this protocol, report to the Conference of the Parties serving as the meeting of the parties to this protocol on measures that it has taken to implement the protocol. Article 34. Compliance. The Conference of the Parties serving as the meeting of the parties to this protocol shall, at its first meeting, consider and approve cooperative procedures and institutional mechanisms to promote compliance with the provisions of this protocol and to address cases of non-compliance. These procedures and mechanisms shall include provisions to offer advice or assistance, where appropriate. They shall be separate from, and without prejudice to, the dispute settlement procedures and mechanisms established by Article 27 of the Convention. Article 35. Assessment and review. The Conference of the Parties serving as the meeting of the parties to this protocol shall undertake, 5 years after the entry into force of this protocol and at least every 5 years thereafter, an evaluation of the effectiveness of the protocol, including an assessment of its procedures and annexes. Article 36. Signature. This protocol shall be open for signature at the United Nations Office at Nairobi by states and regional economic integration organizations from 15 to 26 May 2000, and at United Nations headquarters in New York from 5 June 2000 to 4 June 2001. Article 37. Entry into force. 1. This protocol shall enter into force on the 90th day after the date of deposit of the 50th instrument of ratification, acceptance, approval or accession by states or regional economic integration organizations that are parties to the convention. 2. This protocol shall enter into force for a state or regional economic integration organization that ratifies, accepts or approves this protocol or accedes thereto after its entry into force pursuant to paragraph 1 above, on the 90th day after the date on which that state or regional economic integration organization deposits its instrument of ratification, acceptance, approval or accession, or on the date on which the convention enters into force for that state or regional economic integration organization, whichever shall be the later. 3. For the purposes of paragraphs 1 and 2 above, any instrument deposited by a regional economic integration organization shall not be counted as additional to those deposited by member states of such organization. Article 38. Reservations. No reservations may be made to this protocol. Article 39. Withdrawal. 1. At any time after 2 years from the date on which this protocol has entered into force for a party, that party may withdraw from the protocol by giving written notification to the depository. 2. Any such withdrawal shall take place upon expiry of 1 year after the date of its receipt by the depository, or on such later date as may be specified in the notification of the withdrawal. Article 40. Authentic texts. The original of this protocol, of which the Arabic, Chinese, English, French, Russian and Spanish texts are equally authentic, shall be deposited with the Secretary-General of the United Nations. In witness whereof the undersigned, being duly authorized to that effect, have signed this protocol. Done at Montreal on this 29th day of January, 2000.